First thoughts on mediation. What are the goals of mediation? First thoughts, what are the goals? Resolution. What else? I might be running out of paper here. Oh gosh, I am. Anita, is it possible that is there any more paper in the?
I didn't bring mine because it's collapsible and I thought they had better, obviously they didn't.
It's all right, we'll make
Let
it.
me get
Do this. And then maybe we'll get something after lunch. This will be a trick. Okay. Let's see. So resolution. Others. Call the mediation.
Restoration of relationships.
Restoration of relationships. What else? I promise I can listen and write at the same time. I don't want you to have to wait on me. Other goals. Just pop popcorn. Pop them out. Pardon me? Cost savings. Absolutely. Cost savings. Relative to mediation, goodness gracious, relative to litigation. In Baltimore City, just by way of example, now Baltimore City is not Bridgeport, where we are, or other places in West Virginia. However, for people who don't have any resources, the average cost of a family case, average cost, not to the end of trial, but up until trial through the motions aspect of things for custody, average is, take a guess, what is it? 60. $7,000 was the answer, $60,000 is the data point. 60. And that also is coming to us from legal aid because they're keeping track of the hours, right? And the average cost of a lawyer, 60. Going through all the motions, and something that would be like ex parte potentially in there, or you all have motions in limine and things where people are doing things for piecemeal, right? Okay. Yes, 60. For a litigated custody case, litigated custody all the way to the end, whether it's a 2-day case, maybe 3, what do you think that price tag is? Exactly, it's 120. Say 130. It's really amazing. So even if you're a high-priced mediator, you're going to be saving people a lot of money, a lot of cost savings. Okay, what else? Other goals. Goals for the mediation process. Closure. Interesting, yeah. And closure on what? Closure on
Dispute.
multiple areas. Closure on dispute. Multiple. Dispute is one. What else? Goals. Self-determination is a goal. What else? Information gathering could be a goal. What else?
Resolution.
Pardon me?
Faster resolution.
A master?
Faster.
A faster resolution, sure. We've got resolution and then also just the speed as a process. People are amazed, even in really complicated matters, how we can get on it in a week or two. It's right on in there. Other goals. It's a great list. Other goals for mediation? Why people come? What they tell you. This list, I have so much to chat with you about on this list, which is amazing. Awesome, we are back in action now. Thank you, Carol Merrill, who's with the Moses. You're awesome, Anita. This is a similar kind of list. You know what I'm going to do now. Tape! Ah, the tricks of the trade for the mediator. I I do, by the way, a little footnote, I work with a lot of newsprint in my mediations. I work with whiteboards, I work with charts. I'm often and always writing things up for people. It is an incredible anchor, and it helps people also see more clearly, and it helps them also see process and progress. So, the mediation goals, notice, I'm just going to call them all out to you again. The resolution, restoration of relationships, cost savings, closure in multiple areas, closure of a dispute, self-determination, information gathering, faster resolution. These are not just goals of dispute resolution, right? These are not just goals of settlement, right? I mean, this has come from this room of very experienced practitioners. And I also might add some non-lawyers as well, because I know we have a wonderful group from Disability Center. Where are you guys? Yeah, exactly. We've got some non-lawyers too. And this list is coming from lawyers and non-lawyers. It's exactly the same kind of thing that people are interested in as well. So if we take a look at our orientation to practice, it's kind of fascinating that if we looked at mediation as being a facilitated negotiation only, and we look at mediation being a facilitative process, whereas if we look at mediation being relational, I want you to see where we're going. I'm going to read a facilitated negotiation. If we negotiate every day in life, that could make sense. But oftentimes, and I found this with my law students, I've even had my law students give me data on taking their, I'll ask them to give me a pulse. Give me a pulse on something. They'll come into class and say, okay, where are you? Write it down. Whatever, count how many beats, per minute you have. Right now, I'm going on. Homeostasis. And then later on in the class, I say, okay, now we're going to do a negotiation. I say, stop, take your pulse. It's fascinating. The pulse raises 10 beats a minute on average. Not fascinating, just with the word negotiation. I'm going to put you into a negotiation exercise. Because everybody's afraid that they're going to get out negotiated, right? Or they've got to be on. So we could say that. It's not what we say in mediation in our neck of the woods at Baltimore Mediation. But we could also say this, and this is not what we view, but many mediators do, that mediation is a voluntary process by which parties in dispute, with the assistance of a mediator, identify issues, brainstorm options, consider alternatives, and create, what's the goal here? Agreement, exactly, that addresses their needs and interests. Remember theory, needs and interest theory? This is not a bad or a wrong definition. But interesting when you juxtapose that definition to what you all just said. What are the goals of mediation? Why do people come to mediation? I didn't say what are your goals. I said what are the goals and why do people come? Right? Isn't that the question? You said they come for resolution, they come for restoration of relationships, cost savings, closure, self-determination, information gathering, and for faster resolution. This definition, would it meet these expectations? That it's a voluntary process by which parties in dispute, with the assistance of a mediator, identify issues, brainstorm options, consider alternatives, and create an agreement that addresses their needs and interests. It would probably fall short. You see that? This is a fine definition, but it is one that is very narrow because it believes, the worldview of this mediator believes that what people want most is a settlement, is an agreement. And you just told me that what people are wanting is that maybe it's also other stuff. Sure, there's a resolution here or faster resolution, but what about the restoration of relationships? What about the cost savings? What about closure? What about self-determination? and information gathering. So here's another definition. By the way, you can find this definition written 10 other ways or more. It means the same thing. Similar with the next one. This could be written a little bit differently. This is just the way I've chosen to write. You could take a transformative approach, which is a relational, it's built on relational theory. This is all the work that we do, and so it's what I'll be sharing most with you. But I really believe in understanding and contrasting, because if you don't know where you're going and what you stand for, then the process is probably not going to be mediation, one way or the other. It's going to turn into something else. So here's the definition. Mediation is a process in which a third party works with people in conflict. You see the difference there? Look at this one. Whoops. This is where the facilitative, more transactional approach would be a voluntary process by which parties in dispute work with the mediator. See the difference there? So this one is where it's a process where a third party, which is, I want to show this to you because you can be a little m mediator. You don't have to be a professional mediator to have incredible impact in the world. Maybe at lunch today in this room. You are the third party where you work with people in conflict. We had all this wonderful time this morning. What's the conflict experience like? Right? Not the dispute experience. I personally would, if someone were to ask me, are you in dispute with your son Archer? I'd be like, I don't think so. I hope not. Are you in conflict with him? Oh my God, it was the worst. I drove here just absolutely beside myself. So this approach has a worldview, where mediation is a process in which a third party works with people in conflict. To do what? To help them change the quality of their interaction from negative and destructive to positive and constructive as they discuss and explore various topics and possibilities. You see the radical difference? It's radical. This is a process also that is completely tied to this. Because where they're able to change the quality of their interaction, where they move from something that is negative and destructive, which is the weakness and self-absorption cycle and experience, turn the corner because of you, the third party mediator, to something that is more positive and constructive. And so we are here, there, while they explore various topics and possibilities. What do you think about that? What's your thinking about that? Thoughts? Land? Doesn't land? Doesn't comport? I don't like that. I do it really differently. What do you think?
One thing that I noticed, I like the fact that we took out the moves to be voluntary, because I'm not so sure that both parties always see it as necessarily a voluntary.
Is this your experience? The question or the observation and comment is, I like this because it took out the word voluntary. Because people don't always see that their mediation is voluntary. Do you resonate with that? I do, for sure. I mean, think about it. Think of all the ways people come into mediation. What are some of the ways people come into mediation?
Court order.
Court order. Does that feel voluntary? Right? No way, Jose. Even if both people were relieved that the judge or the attorney put forth the motion and the judge signed it, it's oftentimes the case where one was initiating. By the way, our office, more than 20 years ago, redesigned the very first motion to mediate. And I would strongly encourage you, I don't know how often it's used in the state of West Virginia, but if you have a matter and you are in the court system and you would like to mediate it, you don't have to wait for a court order, you don't have to wait for where that process is, you can do it way on the front end, file a motion to mediate. Judges love them. They say they're being very proactive, and the beauty is that you can begin, a mediator, a good mediator, can begin to also educate on really what happens in that mediation process. You know, they're not waiving their rights, So they don't have to go through all the other aspects of discovery. But they might want to mediate on the front end and say, we still need to discover, like in my world, which we work with fairly complex kinds of things. It's often more than one session. So we'll mediate and say, like, we really need to, this is what's important, this is what we still need to inquire about, this is what we're going to find out. Sometimes we mediate actually a consent decree, or sometimes we'll mediate their own discovery guidelines. Like, what is it that they're going to be asking of each other, and what period of time do they need to do that, and then they'll come back into the mediation process. But you see, the power of a motion to mediate is that it gives you a lot of ability on how it is that you want to have a practice that really is quite responsive to the needs, for the litigators, that is, to the needs of your clients. So, this is a definition. We're looking to why it is that people come into mediation. We also know that they're not necessarily coming to say they want it settled, and we know that they don't experience that they are there voluntarily. What's another way people come into mediation besides a court order? That's a good answer for a group of litigators. What's another good answer? How do people get to mediation? Okay, very nice. The lawyer recommended it. By the way, for every single one of you in this room, even the non-lawyers as well, you're a trusted advisor. You are a trusted advisor. People look to you for your wisdom. They look to you for what you think might help them. And if you are, in your role as trusted advisor, the one who says you might consider mediation, or really think it would be a really helpful thing for you and the other person or other side or whatever the context is, guess who comes out smelling like a rose? You. It's a natural, amazing thing to recommend mediation. Of course, you want to have them in a good mediation process. Choose your mediator well. Choose your process well. But people will remember, like the way Michael and I remembered, our early days when we first met. We remember those things. We remember the people who are looking out for us. And you can do that in a way that's very beautifully sort of ginger for them and for the other. Sort of, just another piece on that. We don't help each other when in our advocacy of life, in the role of trusted advisor, when we really vilify the other person who's causing the person whom we have a relationship with, whether they're a client or whether they're in our household, when we vilify the other person, because it really destroys the person's sense of their own judgment who we care about. I mean, they were the one who hired that person. They were the one who married that person. They were the one who did business with that person. They were the one who did something other, with that person. And the more that other person is vilified by our way of showing love, the more we destroy the person who we actually care about. Yes?
Louise, a question about transformative mediation. I've seen it work in the labor environment, commercial disputes, but how well does it work personally in litigation?
Oh, it's great, yeah.
And maybe some of the mediators in the room could offer their thoughts on it.
Terrific.
I see it as less effective.
So you might. The question is, having seen, from your experience, tell me your name. Bob. So Bob has seen transformative mediation work really well in commercial disputes, and labor disputes, and you didn't say like family disputes, but you're really questioning, is it possible to mediate through a relational lens, a personal injury dispute? Anybody want to comment on that? Because he was also inviting anyone else who might have experience with that. I can't wait to answer this. I sat on the inaugural AAA of the American Arbitration Association's Dispute Resolution Committee personal injury pilot on that very topic. So I'll tell you about that. Anybody else want to comment? Yes.
From my observation, mediation continually with consulting and success. I believe that that's the human the political situation, the national political situation, is to be able to kind of make decisions by the insurance industry for personal injury mediation. It's almost
So one comment would be just around mediation
Sorry.
generally. That's okay, we have context. Would be that mediation, whether it's transformative or whether it's something else, is worthless in personal injury cases because of the changes in the insurance industry in the state and how things are handled and how things are handled. Right? I think it's an astute comment that wouldn't just be West Virginia. I've seen it in a number of other states as well. I mean, insurance. Anybody here from the insurance company? Yeah, it's a pretty highly transactional process where you can try and convince them all day long of how someone has been really injured, or even defense counsel can't even get through to the people who have the authority to shake the money bags a little bit more. Is that sort of the state of the land? Okay. So where transformative mediation has been really, really effective in personal injury is a number of ways. Number one, we don't separate the people. If people want to have caucuses and be in separate rooms because that's what they've chosen, that's fine. It is not a caucus model. So that insurance adjuster or adjusters and that plaintiff and that defense counsel, and hopefully you have a defendant there too. So you've got plaintiff's counsel, plaintiff, defendant, defendant's counsel, insurance adjuster. Sometimes you don't even have the defendant. Am I with you on the lay of the land? Okay, right. That's a drag. So what you can do, and we do in our private practice, is we would say that person needs to be there. And they'll kick and scream, but they live in California, Mrs. Stumpf, are you going to make us pay for the plane ticket to Yep. It's mediation, face-to-face dialogue process, etc. You have to stand for something. Okay, so you might not have everybody there who you need, but let's just say, in our practice you do, but let's say you don't, because that might be more common. Transformative mediation is so incredible in those matters where someone says, look, it's just about the money. They're wanting, $500,000. We put $1,500 on this case. It's a nuisance case. Am I about right? You have the idea? Sort of something like that? And the media might think, oh my goodness, where do we begin? But one of the beauties of transformative mediation, and I'm actually ahead of myself in answering this question for where we want to go, but I don't care if they're going to settle it or not. And I don't say that flippantly, like, oh, I'm just going to be there, I don't care who's going to pay me. No, I care deeply about that quality of the interaction. And someone says to somebody else who has been seriously injured, and it could even be laced with it's nothing personal. Tell me your first name. Mark. I'm an insurance adjuster. Mark, look, it's nothing personal. I know that you don't have, that you've injured yourself, but really look to Mark's counsel. It's just a money case, and we're probably not going to be able to do anything with it today. We're just too far apart. We're coming here in good faith. Maybe we can, separate. Or you go talk to the mediator, and she'll tell you that we're too far apart. I'm in high cotton at that moment, so be like, okay. Now I'm mediating the insurance adjuster, which happens to just now be Louise. Okay, so Louise, so really, you're saying to Mark that it's nothing personal that he was injured, and maybe be like, it's nothing personal that he's lost his arm, or it's nothing personal that your driver did blah blah blah. It's just about the money. I'll pause, and people will do things like, well, it's just my role, Mrs. Stumpf. We're here in good faith, but really, it's just about whether we can come up with the right dollar amount. So for you, it's really, you're here in just your role, and it's really about just finding the right dollar amount, because you're just in your role. Well, I am here in my role. Look, I'm sorry this happened to you, man. Like, oh, okay, so you're sorry that happen, Mark. I'm here in my role. Hey, things are tough. I've just got a job to do. I'm sorry that happened to you. I can see, I can only imagine. I do these cases, a lot, and I've read the stuff. It's pretty injured, but there's only so much I can do. I'm just here to find the right number. Do you see how different that is? That's a completely different experience for Mark. And it's a completely different experience for Louise, the insurance adjuster. Because something in that interaction, I didn't do anything. I just had a good skill set that believed in focusing on the quality of the interaction. Because we can't help ourselves to be human. That's the beauty of living on this planet at this time in our evolution. We have a desire, we know this through science, we have a desire to be connected to other people. We do not have the desire that they like us, that we love them. It's a desire to be restored as we live our lives. Notice, I was still very clear that I have still my role, still all just about the money, but all of a sudden it's not just about the money. I can have this experience. And in doing those personal injury cases, Bob, that's what I found. I found the most extraordinary things. I'll give you a tiny anecdotal story. I remember so distinctly an adjuster. It was a case that wasn't catastrophic or anything of that nature. It was a case where someone had been rear-ended, and they thought that the plaintiff was a malingerer, and things should have been resolved, and then she had issues again and was coming back, and they just couldn't close it out. You with me? Those kind of cases? They're the most common, really, right? Hello? Yeah? Okay. So, in that interaction, and the adjuster was a woman. Plaintiff was a woman, adjuster was a woman. Not that that matters, but just to give you sort of as you're picturing it. And the adjuster said, it's really just about the dollars. How many times does a mediator hear that? They said, so it's really just about the dollars. Yeah, and I don't know what you do, Mrs. Sempt, but I usually don't stay in the same room with everybody else here. I'm ready to go into another room right now. And I said, okay, so you usually don't stay in the same room. You're ready to go into another room. You may. Is there anything you would like to say before you make that decision to go in the other room? And this, we've been around and about on this for a little bit. And everybody's a little uncomfortable, because I told them when we opened that they could meet separately. Don't count on me to separate them, because I believe that all the action was in the room, but if they wanted to, I would follow them. They didn't, right? Because they're still thinking that I'm going to make all the decisions for them. So she registers that she's a little uncomfortable, and so I ask an open question, is there anything else that you would like to say? And she turns to the woman, and it was a teeny tiny one of those. They had like $500 or $1,000 on it, but they had been in this litigation for like 2 years, 2.5 years. It was just, oh, you know what I'm talking about, teeny tiny like little matters. And they weren't asking for the world, but I think it was something like, $25,000 or something like that. It was all about her back. And she turned and she said, off the record, my sister had the exact same thing happen to her. She got rear-ended, and I run you through our system, and you're a number in our system, and it tells me that this is all I can pay. I do have some money today, but it's nothing like you're talking about. But I just want you to know that I believe you. Isn't that powerful? It's amazing. It was amazing. Because that little piece of humanity. You think that case settled? Yes, that case settled. You know what that plaintiff said? It's been about 2.5 years, I think it was. Maybe a movement of 3, but whatever, you get the idea. She turned and she said, that's all I've ever wanted. He said, I don't want to file any claims. I have health insurance. I have a real bad back, and I'll get care for it. But nobody believed me. I had to do a deposition. I was like made fun of. He said, that's all I needed. It was powerful. So I do think that there is a role for transformative mediation and personal injury, and I think actually in some ways even more so. Anytime I hear, in commercial cases, and we manage huge commercial cases, like we did one with the Blues, right? The Blues of Minnesota, Blue Cross Blue Shield of Maryland, and it was on millions of back pay in dollars and so forth. When it's just about the money, that's when the relational transformative mediator can really be, I think, of great service. Yeah. So let's take a look at what's next. And that is, in the process that we follow, that you can consider following, it's a very circular process. It's circular because in an agreement-oriented process, it would be very linear, right? And that definition I gave you, the goal, the mediator would have the belief that people come into mediation because they're looking for a settlement. And so what the mediator would be doing would be lots of things to bring about settlement. She would get the parties to do things, she'd probably separate them. Why would a mediator separate parties? Well, why would a mediator do that? But so I asked that, like, why would a mediator do that? And now I'm really serious, because I bet you've done it. Why would a mediator separate parties?
Further hurt feelings.
So with the belief that the mediator is going to prevent further hurt feelings between the parties, so who's uncomfortable with that being expressed? Further hurt feelings. The mediator. That's right. So the mediator is really protecting himself or herself, separating the party, when the belief is, oh, but they might hurt each other more, right? Does that mediator believe in the party's self-determination? Probably not. The mediator believes more in her own determination of what's going to be helpful or not. So this is tough. Well, this is a tough love conversation right now. Why else might mediators separate parties? But that's a great answer. That's exactly one of them, for sure. Why else? They do, the parties do not, they not only have a tough time in the mediation room, they can't even be in the same neighborhood together. They do not like each other. So what would be the reason for the mediator then separating them if they do not like each other? Because it's dangerous. So, amen. I mediated in Chicago in Cabrini Green, and I am very serious about things being dangerous. So I take it seriously, but I also hear it that way. Okay, so people don't like it. They're going to potentially be in danger, but they just don't like each other. Why would a mediator separate them? Because they don't like each other. Do you think people in dispute like each other at that moment? No. Do you think you had a conversation or an argument with somebody and you liked that person in that moment? No. Did they like you? Did they think you had horns on your head, maybe? Maybe, probably. Did they think you didn't want to be around you for a while? Probably so. How is it that those people could be restored if we separate them with the belief that, well, they just don't like each other, so why keep people together if they don't like each other? Okay, let's go. There's more to it than that.
People are less likely, you're less likely as a mediator to develop a relationship, connect with someone if you're all together and there is the sense of tension. People don't want to talk.
So the mediator is less likely to develop a relationship with each of the parties when they're all together. Why is that? Why is that?
Because they don't want to speak.
Because they don't want to speak.
Because of it, everyone is seated around the table and that's what they want.
So everybody's sort of shut down, reluctant to speak. Yeah, right, it could also be your experience. How many of you had that experience? Yeah, I've had that experience too. But I'll tell you why I didn't separate people. Because I knew that that experience was my own. That it was my discomfort. And that I wanted to develop some relationship and I wasn't able to. Put me on that chart earlier. I was ineffective, right? I was self-absorbed. Deep breath, as Michael reminds us, I could do something very differently. So people are shut down around resistance. One of the things that will keep them shut down is to resist them back. So you make something that's very opening and very, very welcoming. The piece that I want to bring to this is ethics and how it is that you might consider doing that. Because there are a lot of legitimate, good reasons for why we might separate people. I am urging you to kick the tires on those reasons and look harder at what is underneath and what we know about the conflict experience and what people are yearning for and how it is that you as a mediator can be an extraordinary mediator because you believe differently in the capacity of parties. Here are our ethical standards of practice. There are 9. These are national standards. They also exist in the state of West Virginia. Self-determination. Self-determination was changed. The standards were changed in 2005. They were the second pass at standards of practice. Self-determination used to read that the mediator was to assist the parties in coming to a voluntary agreement. It now reads, the mediator is to assist the parties in coming to uncoerced decisions about both process and outcomes. So if 2 people thought in coming to mediation that they couldn't be in the same room together, and they made that decision, we will follow those parties and follow them around. Self-determination might mean that the process just isn't working for them. And then you ask, what would be helpful? And they might tell you, so long as it doesn't conflict with the tenets of mediation, which are these, you follow through. Self-determination will be people saying things to each other that might give you the heebie-jeebies. They'll say things like, if you're in the family arena or the employment arena, things really fly. Or if you're working in the business arena with partners, you're a shit. You fucked me. Well, you've got to be willing and ready to allow them to have that kind of an interaction, because that is their self-determination that will unfold. Self-determination is around the process and the outcome. If we are better at understanding our theory, and we believe, you are like I, in relational conflict theory, that what matters most to people is being restored because of the fracture in the interaction. The fracture in the interaction is happening like crazy throughout the mediation process, everywhere and all over the board. The self-determination is to allow the participants to decide how it is that they want to be. So, self-determination might be a mediator using her skill set to say something like, so you feel, let's just say someone said you really screwed me. So you believe that so-and-so really screwed you. No, I don't believe it. He did. He did. Absolutely. He screwed you. Open question. What is it that you want him to understand most about what that's like to be screwed? You have no idea. I thought of these things. I had my kids' college payments to be able to make in August. I had to go back to the school and I told them I wasn't going to need a payment plan. I had to pay extra fees. I had this happen and that happened. And you're going to, okay, so you had a college payment plan, you had this happen and that happened. What is it that you want to be able to talk to him about? Orienting them on self-determination. I didn't choose, I didn't decide, I gave him the opportunity to be able to say that to the other person. That can't happen when we separate people. It can't happen in 2 separate rooms. And if it did, and I was back in the back, one guy says, let me just tell you, he's a lout. He has really screwed me. And you know what? All this stuff that's happened to me, he doesn't care about it. I had to make my kids' college payment. I couldn't make it. I had to go back to their school. I had missed the deadline. I had to pay all these fees. I had to write a letter. You know how degrading it was? I had to write this letter that I wasn't able to pay, and I had actually, made a big, said a big deal like, of course, I thought it was such a reasonable, college tuition, and it just got where he doesn't care about that, and they're talking fast like this. And it's like, so, and I'm in caucus with them. And I might say, okay, so when we come back, what is it that you want to discuss? Oh, none of that. So you want that confidential. Yeah, it doesn't even matter. They don't care about it, doesn't even matter. Okay, so, and I'm not going back to talk to them now that they're in caucus. Nobody wants to return. Oh, so you don't want to go back and talk to them. So, yeah, you can go back and talk to them, Miss Mediator. Okay, What does that look like? What do you want me to tell him? Just tell him that, that he's done something that's really wrong, and that I need to get my money back. So you want me to tell him that he's done something really wrong and you need to get your money back? Yep. I believe that. Yeah, he really thinks you've done something wrong and you get his money back. You know how ineffective that is? When somebody could say, "You screwed me. I wasn't able to make this payment. I looked like an idiot. I had to go account for it. I had to write this letter. We were in business together." Or, we weren't at all. You're the bank. We were like arm's length. It's a totally different experience for people. Self-determination allows for people to be able to speak freely. Voluntary is what comes in on self-determination. Mediation is often not voluntary for why people get there, but what they choose to speak about, that is what is voluntary. And that comes squarely, if you were to read more about self-determination, that is where it comes from, the ethical standard of self-determination. You have impartiality, which is the byword for neutrality. We oftentimes say that mediation is a voluntary, neutral, and confidential process. Well, neutrality is housed right here in the standard of impartiality. Now, how is it that you can maintain your neutrality when you're making all these decisions for people about whether they should even be separated or not? You with me on that? The standards are actually very highbrow in some ways. But I teach ethics, maybe some of you do too. You've got shall, should, and may in ethical standards. These are all the shalls, under which are some of the shoulds, under which are some of the mays. So let's get clear about that. Shall, in mediator parlance for ethical standards, should you do it? You shall, like Moses, right? You shall. You have a problem if you don't. Should, highly recommended. Have a very good reason if you don't. That's what should is. May, what do you think? Discretionary, exactly. You may, depending on your own judgment. Impartiality on the standards, look them up. Well, do a quick Google search. You can tell us, ask Siri for them, on a break. Impartiality says that a mediator is to be free from bias and prejudice. I love that quote Michael gave earlier this morning about how we're just, in our thinking, we're just rearranging our prejudices. This is where self-awareness comes in. You might think, gosh, I've not seen a training that brings in self-awareness. Well, ours have for 24 years. Because how else is it that a mediator can breathe life into being a neutral if you don't understand your own biases and prejudices and proclivities and leanings and recoiling? We all have them, we're human. But the awareness of them allows us to set it aside. The awareness of our own biases and prejudices allow us, when we're in the mediation process, to set them aside. So impartiality is a pretty high-minded standard, ethical standard for mediators. Let me pause on that. Thoughts, ideas, tired, yes.
I give you 3 reasons why I went from believing to preaching to go to my own door.
Yes, please, 3 reasons.
Big disparity between the parties and most of the mediation, so that my clients live there, which is like, there isn't self-determination.
Can you hear? All right, so I'll pause. So 3 reasons being given for the way that you would mediate in your world. Number 1, there's a big disparity in family, because you do family mediation.
That's correct. Number 1.
So big resource disparity?
No, well, it's usually psychological, one's the talker, one's the pusher.
Or big psychological disparity?
One's not.
So because one is the talker or one's the pusher and one isn't?
The best mediator I've ever dealt with in family law, the one who was successful 80% of the time, prefers it. So I like to go along with what he does. And that, the better mediators can filter the vitriol of the accusations, but pass on the essence of it to the other side, so you get the feeling.
So are you in
This
the,
really fantastic mediator says, this is how the lawyer's acting in the other room. This is the demeanor of your spouse. Your spouse really is working hard today trying to come up with a solution. You would be surprised the wonderful things she's saying about you. And it is so brilliant and so psychological that even though some of it's BS, it really works. And I have seen transformational things happen between people because when the other person says, this is a rotten, no good son of a bitch who should die and I want to spit on his grave, he goes in the other room and says, your husband's or your wife's
so the reasons that,
That has changed me
Yeah.
from the blood and guts. The other thing is,
well, hang on, hold on. Guys, the rest of the group can't hear you. So this is why you prefer caucusing?
this is why
Put in context.
I consider it the norm in family.
Okay, so hold on a second, we have to tell the rest of the group. And tell me your name? Bert. So Bert says, I prefer caucusing because there's too much disparity between the parties. One talks, one doesn't, and one does this, one doesn't. The other reason is because when people are separated, then the mediator can come and report what's happening in the other room and soften it and reframe it and have a lot more control that way. Those would be what we call reframing. It's classic reframing in that regard. Even if, or it says, even if it's BS, it can work.
But usually there's a real core of honesty in these guys.
Okay, so there's a core of honesty in the way it can be done in mediation. Okay, all right. So it might be BS, but it's got a core of honesty. All right. Is there anything else you want to add to that? That's
Well, I
two
like the
reasons.
fact that it's highly successful. Oh, I know. I have 12 fatalities in my practice, 4 murders, 8 suicides. I've had my door super shut. I've done it for 41 years. I'm 71 years old. The emotional energy to do a face-to-face is just amazing. My blood pressure will stay perfect, but for most people, it just eats them alive. Lawyers have rough enough jobs.
So the third would be, I'm going to try and put these to get stressed, that you would do caucuses because it's too stressful to have people be face-to-face. Day in and day out.
I think it was just
And you talk about because you've got murders and super gluing your door shut and
3,500 cases, 12 fatalities, I think.
12 fatalities,
Doesn't happen that much in personal injury matters.
and all in domestic cases.
Yeah.
In 3,500 domestic cases, you had 12 fatalities in a super glue door. So you would
I've been
prefer,
told I'm a dead MFer if I walk out.
and you have been told by clients that you're a dead MFer.
The other guy.
The other guys, the other side. Okay, not the client, all right? The other side, that you are, and with that kind of a threat, that you're a dead MFer. if you walk
So it's
out.
a very stressful.
Very stressful. Yeah, very, very stressful.
Yeah, we've got metro opioids now and the high suicide rate in the nation.
Yeah, I know that
There's even a book about it called
right, the book. So let's take that, actually, because in this, on self-determination, the choice about whether to be in a separate room or together would be whose choice? The parties. It's not the mediator's choice.
It's the party's lawyer's choice.
And it is often the party's lawyer's choice. That's been my experience as well. So, as a mediator, we're following the parties and we're following through. So if it were their choice, is the mediator going to say, no, you guys stay together face to face? Am I going to do that? No, absolutely not. Right, for their own self-determination. So if we were mediating with Bert, and Bert said, by the way, Louise, there's no way that I'm going to allow my client to be in the same room with with other client. You think I've had mediations that start that way? Absolutely. You have to take people right where they are. Say, okay. And then I would be talking to Bert and say, Bert, part of my job is on self-determination. I'm going to check in with you on that and see if that's changed at all later. It might not. It's perfectly fine if it doesn't. But if it has, I want you to know you're always welcome to come back together. So what do you think would happen in that private session? Caucus. That would happen in a joint session.
It's noon.
Oh, it's noon. I'm thinking, thank you. We're doing a whole clinic here. Thank you, thank you. So I'll finish this up. Do you think that it would be as effective in that private one-to-one session as it would be in a joint session under these circumstances? Yeah, you might be more likely to get concessions and opportunity to develop rapport. But I would go with the wisdom of Bert, right? I'd go with the wisdom of the client. If they know they can't be in the other room because the person has hurt them so badly, or we don't know what happens in their homes, you're going to follow that. Transformative mediators don't follow that. What I'm not going to do, though, is dilute what the other person is saying to me to the other. If they want me to tell the other person the way it really is. They're going to hear it exactly the way it is. If they want me to dilute it, I will ask them exactly how. I am not going to refrain that for them. Because I believe too deeply in people's capacities. And I will tell you that in working one-to-one, you oftentimes will go from people who are very, very highly vitriolic, as you said. And they will have their own experiences of empowerment and recognition. And they'll be like, well, he's done, look, I'm not going to go in there. He hasn't paid child support. He doesn't even see his sons. He's a lout. He's got, he screws all these other women. I think he's got 2 other kids. I don't know. He calls me a slut every time I see him. He poisons the kids. He drinks in front of them. He's got dope in the back of his car. And on it goes. And if I were to say, what part of that would you want me to share with him? Because he's got da-da-da-da-da-da, enumerate it. And she might say, none of it, but I will say this. He cannot drive drunk if he is ever going to come see the kids. She might have her own experience of a shift on empowerment and recognition just with the one-to-one. It's not that caucuses are wrong. It's who's choosing them. And what I will tell you in doing thousands of mediations, people want to come back together. And we want it to come back together after lunch, and we will continue this. So we'll see you back here in an hour and 15 minutes at 1:15.